now being recorded.
Welcome to the New York State ASBO webinar, 3028, Section 75 in Progressive Discipline. My name is Matthew Darius. I am the Senior Staff Associate for Professional Development here at ASBO, and I'll be moderating today's webinar. Your speaker for today's program is Eric Wilson from the firm of Ferrara, Fiorenza, Larison, Barrett, and Reitz. Operator assistance is available at any time during this conference by pressing £. Questions for Eric may be asked at any time by pressing £7 on your phone to speak with him over the phone, or using the chat window located to the right of the main presentation. At this time, I'll turn over control to Eric. Please begin.
Good afternoon, everyone. It's a small group today, so please feel free to, present any questions you may have through the internet. I'd really like it to be kind of a dialogue, and I'm sure that some of you have specific cases that you're interested in discussing. With that, we'll just get started with a general overview. The way I like to explain this, because it's a foreign concept to most people, especially people who have worked primarily in the private sector. The Constitution gives due process protections to all of us, both the New York Constitution as well as the federal Constitution. And in essence, that means that the government cannot deprive you of property or liberty without due process. Generally speaking, the due process associated with a deprivation of property is less than what it is for liberty. So, for instance, if you're accused of a crime that carries with it a potential incarceration sentence, the due process
Eric, do we have you there? Okay, it looks like Eric got disconnected, so just give us a moment here for him to call back in. All right, just bear with us, please. I'm going to go ahead and give Eric's office a call and see if we can get him patched in ASAP. Thank you very much for your patience.
Hello.
Eric, is that you?
Okay, am I back on?
You're back on. Yep, we lost you there for a couple minutes.
Okay, yeah, I apologize.
That's all right.
I'm doing the conference from a school district in Western New York, and because I have negotiations here later this afternoon, and they were good enough to set me up with a speakerphone, which apparently has some problems. So I'm doing this from my cell phone. If there's any problems with anyone hearing me, please, Matt, if you can let me know, that'd be great.
Really? I think you sound better with this phone anyways.
Okay. I'm not sure where we left, where I got cut off, but
you were just starting out.
Okay. What I wanted to do was explain the difference between the employment relationship in the context of public employment and that of private employment. There's a significant difference, and really that's associated with constitutional protections, both the federal Constitution and the state Constitution. When we talk of the Due Process Clause, that's contained in both the federal and the state constitutions, and in essence what it says is that you cannot be deprived of liberty or property interests without due process. The liberty interests are protected to a greater degree than the property interest, and you see that in criminal proceedings where the standard of proof for the prosecution is beyond a reasonable doubt, because what's at stake are people's personal liberties and incarceration. With regard to the deprivation of property, the due process afforded to individuals before the government can take property is something less than that. And why that's important in the context of discipline is that once a person receives tenure, whether it's a permanent competitive civil service appointment or tenure in a certified instructional employee, that person is deemed to have a property interest in their job. So they own it, in essence, the same way you would own real estate or financial assets, and the government can't take that from you without some measure of due process. As I mentioned before, the due process associated with deprivation of property interest is less. And really what we need to demonstrate in both Section 75 proceedings and in 3028 proceedings is that it's more likely than not that the person is guilty of the charges for which were brought against them. And once we demonstrate that, once we meet that burden of proof, we can move forward with the appropriate measure of discipline, which is not always termination, and the purpose of which isn't necessarily punishment, but remediation. So that's kind of the constitutional background. Tenure, both Section 75, permanent appointment associated with the classified civil service and tenure associated with the unclassified civil service are statutory creations. In essence, the New York State Legislature created a property interest in the jobs at various levels. All right. Teachers, administrators, and teaching assistants receive tenure pursuant to the education law. And as we all know, that's pretty much after a 3-year probationary service. Non-instructional employees receive permanent status under the civil service law. So those individuals at that point, once a teacher, administrator, or TA has been appointed on tenure, now have a property interest in their job, or if you're a non-instructional employee, once you finish the requisite probationary period, which is different from county to county. In some counties, it's 26 weeks, and in some counties, it's 52. And once you have received permanent status, you then have a property interest in your position. What is the procedure for granting tenure to a probationary employee? Instructional employees, okay, the superintendent must recommend the individual for tenure, and the Board of Education must then offer an affirmative vote to appoint the person on tenure. Neither can act alone, neither can grant tenure alone. It's a symbiotic relationship. And it's usually after a 2 to 3 year probationary period. 2 years if the teacher had been tenured in another district, 3 years if they had not. Non-instructional employees, no board action is required, although often boards do act at the end of the probationary period. So at the end of the 26-week period or 52-week period, actually a few weeks prior to that, Generally, the supervisor will make a recommendation to the superintendent, and there'll be some note on the board agenda. That's not necessary. As I said, the appointment ripens into a permanent appointment at the end of the probationary term. But generally, it's not a bad thing to have the board act or to have a process by which there's a review towards the end of the probationary period where the supervisor makes a recommendation. At least that way, much like the more elaborate processes associated with tenure, there's some level of certainty on the part of the administration and the board that this is an employee that deserves to continue working in the district. I'm not moving along to the next slide. I don't know if you can help me with that, Matt.
I don't see any issues in my end. Let me try one thing here. You're going to see your screen change there, Eric.
Okay. What you need to know about tenure. A teacher granted tenure effective on a future date is not entitled to the benefits of tenure until the effective date specified in the resolution. Early grants of tenure can be revoked. This is not all that uncommon. This was a Court of Appeals case, and in this particular case, the board had appointed the individual in May, I believe, to tenure effective September 1st. Well, over the course of the summer, it came to light that the teacher had been arrested, and at that point, the board acted to reverse their decision on tenure and revoke the grant. And the Court of Appeals said that was fine so long as the person had not worked on the effective or past the effective date of the grant of tenure. Okay. Once tenure is effective, how do we discipline for misconduct or incompetence? And it's changed a little bit, and we'll talk about the change. Disciplinary hearings. Instructional employees with tenure go to a hearing pursuant to 3020A, and non-instructional employees with tenure or permanent appointment are afforded the rights of Civil Service Law, Section 75. Now, the Civil Service Law applies only to competitive class employees who have reached permanent status or non-competitive class employees who have worked for 5 years or more. And that's most oftentimes your bus drivers. Your bus drivers are an excellent example of non-competitive class employees. They don't have to take the civil service test and be reachable pursuant to the Rule 3. They simply have to meet the minimum qualifications for the job, pass the fingerprinting test as well as the drug and alcohol screening, the 19A exam, and they can be appointed without having to take a written civil service test. For the first 5 years, in essence, they're probationary in terms of being able to discipline them. Once they reach that 5th year, however, they don't need it. They have Section 75 rights and have to be disciplined pursuant to the terms of Section 75. Now, I want to make it clear at the outset that many of your collective bargaining agreements give greater rights to employees than Section 75. Oftentimes there's binding arbitration, and they also may extend either binding arbitration or Section 75 rights to non-competitive employees sooner than that 5-year period, or even to labor class employees after their probationary term. That's not at all unusual. And when we get into more of the discussion about Section 75, we'll talk about how the contract can play in and how binding arbitration might be a little different than the rules associated with the Civil Service Law. Now, this is data that NISBA put together, and it's just interesting. It shows the average number. It gives you an idea what the cost and the length associated with a 3028 proceeding is.
Now, this data is as new as I know it to be. It's from 2009. I don't know if they've generated any new data. But it shows you the average number of days between the time the charges are levied or voted on by the board and the decision is issued. So, it's varied a little bit. But if you look for 2004-2008 period, it takes almost 2 years, at least a year and a half, to get from the situation where the board has voted the charges on 3020A to a decision from the hearing officer. Now, you have to keep in mind that very few 3020A cases go to decision. So some of them are settled before charges are brought. Some of them are settled during the pendency of the arbitration proceedings or the hearing, and some of them are settled before a decision comes down. So while that's true for the ones that go to decision, the majority of cases settle before that point. This gives you an idea of what the average costs for an employee are. You're going to pay the employee salary and benefits during the pendency of the hearing. You may or may not have them on an alternative assignment. You may keep them in the classroom, or you may send them out on administrative leave, depending upon the nature of the charges. But on average, that cost is almost $140,000. And then the cost of substitutes is another $75,000. And then the average staff days, you're looking at probably 21. And by that, we mean the number of days that people are going to need substitutes, are going to be out of the office to deal with the hearing. So that, even without legal fees, is running you around $200,000. If you're quick, you might figure out that the $75,000 paid to the substitutes is really what you're out of pocket, because you're going to pay that teacher their salary and benefits in any event. But the $75,000 is new expense money that you're going to have to pay. Here are some of the penalties imposed. And again, you have to remember that these are the ones that go all the way to a decision. There are a lot of resignations, retirements, fines, suspensions, all sorts of different things that occur with charges that are brought but don't go all the way to a decision. Acquittal, 17%, reprimand, 11%, fine, 6%, unpaid suspension, 28%. But the biggest group is almost 40% being terminations. And the reason that is that, remember, you have the most egregious cases are the ones that are going all the way to a decision. All right, and this gives you a breakdown of what the costs are. The legal fees certainly are not inconsequential. They are significant. It's a little hard to distinguish between the colors, but the substitute fees are the third, and the legal fees are the 12%. So, the lion's share is the suspended teacher's pay. You have other staff costs and legal expenses. The legal expenses vary considerably based upon the nature of the charges, the length of the hearing, the number of witnesses, that type of thing. I've had hearings that have lasted half a day, and I've had hearings that have lasted for more than 20 hearing dates. So obviously, the legal fees associated with that are considerably different. New York State's enhanced fair hearing. Very few very few states have the type of process that New York State has with regard to hearings for tenured teachers. Ours are extremely time-consuming and expensive, and the rules of evidence and the process is stacked against the school district. Teachers have both Weingarten and Condé rights. So, and when I say teachers, I mean instructional employees. So that would include your administrators as well as teaching assistants. Weingarten rights, most everyone's familiar with, means that the employee is entitled to union representation at any interview in which they believe that a disciplinary charge could arise or discipline could result. Cadet rights are perhaps the single most ridiculous right afforded to any employee anywhere in the world. And as far as I know, teachers in New York State are the only ones that enjoy this right. This is the ability of the teacher to refuse to answer questions during an investigation into allegations of misconduct or incompetence. So a teacher can be called into an interview with the superintendent, the business official, the director of personnel, whomever, and you can ask them questions regarding allegations of misconduct. They can refuse to answer based upon the fact that they believe their answer could lead to disciplinary charges. Now, non-instructional employees can refuse to answer, but that is grounds for another charge. That's grounds for a charge of insubordination, because you can direct them to answer questions regarding their employment. Why teachers are afforded the additional protection has to do with a commissioner's decision, the matter of Cadet. That's where the name of the right comes from. And simply the commissioner found that there's no obligation on the part of the teacher to incriminate themselves, so they do not have to answer the questions. If they don't answer the questions, you cannot charge them with insubordination. So it's an added measure of protection that instructional employees have that no other employees anywhere, including non-instructional employees in schools, have. The teacher has very liberal disclosure investigatory material, so they get everything we have on them, literally all our notes, their entire personnel file, any communication that went on with regard to them, the investigation file, any police investigation reports in the possession of the district, any private investigatory reports in the custody of the district. So that is huge for the employee. The district has no right to request documents from the employee prior to the hearing. At the hearing, they can subpoena them, but they don't get them before the hearing. There's a 3-year statute of limitations for instructional employees, and that's one of the big differences between instructional and non-instructional employees. In Section 75, the statute of limitations is a 1.5 years. So for teachers, administrators, and TAs, you can only go back 3 years to charge them with acts of incompetence or misconduct. And in the case of non-instructional employees, you can only go back 1.5 years. The hearing officer in the case of a 3020A is the final decision maker. You can appeal to the Supreme Court, but the grounds upon which you can appeal are very limited, and I've had limited success in making those appeals. I have been successful on occasion, but generally speaking, the court gives great deference to the hearing officer's decision, and it is final. All right. Yeah, the biggest issue, I mean, the way to handle this the best is to be very careful about who gets tenure. And that's easier said than done. One, you may have administrators in buildings that are close to retirement. You may have a change in administrators during the teacher's probationary period. The teacher, a young teacher, may be a very effective teacher who acquires bad habits or bad behaviors later in their career. But really, that first 3-year period or 2-year period, depending upon the length of the probationary time, is crucial to make sure that this is someone that you want to give a property right to in their job. Because up until they get tenure, they do not have a property right, and it's fairly easy to terminate their employment. So that's the first caveat. There are alternatives to tenure. There's what's called a Feinerman Agreement, which means that the individual can waive their tenure rights. It has to be a knowing waiver. The union has to sign off on it. The employee has to sign off on it. And it's got to be very clear that they know what they're signing off on. So that is a possibility. It's not often used. I mean, unions guard the right to tenure very closely, and they're very protective of it. They will not advise people to execute Feinerman Agreements, but I have used them, especially with administrators, and they can be effective tools in unique circumstances. Juul Agreements, most everyone's familiar with. They can add an additional year or more. Actually, they can extend the probationary period indefinitely. Again, they have to be executed by the employee and by the union, and they're knowing waivers of tenure rights. Again, they're difficult because they're difficult on both sides. If a superintendent goes to a board of education without a real good reason for a Juul agreement, meaning, let's say, we're not sure about this teacher, he or she has some very strong points, but also there's some things that we're concerned about. Most boards of education are going to say, get rid of them. You know, if there's a question, why keep them? Find somebody else. So that's generally not a good enough reason. Sometimes there's been change in administrators, so that you have one administrator very positively commenting or evaluating on the teacher, and another administrator not so. And what you need is more time for that person to be observed and evaluated. That might be a reasonable reason for a Juul agreement. The other reason might be a very practical one. You're in a rural district, they're certified in a high needs area, and you don't think that you can find somebody. So you extend it for another year. All of those are reasons that boards might be inclined to offer Juul agreements. Generally speaking, I think boards are adverse to them, but it is possible. And the other alternative is simply to say no, that you are not interested in granting the person tenure. All right. Grounds for discipline. No teacher shall be disciplined except for just cause is another added protection, and we're going to talk a little bit more about what just cause means. The specific charges are insubordination, immoral character, conduct unbecoming a teacher, inefficiency, incompetency, physical or mental disability, neglect of duty, failure to maintain certification as required by the Commissioner's regulations. So those are pleading requirements. Those are the things for which you can discipline a teacher. Tenured civil servants are covered by Section 75 of the Civil Service Law, and they include permanent appointment in the competitive class of the civil service. We talked a little bit about this. Custodians are generally competitive appointments. So they take a test, they're reachable, you appoint them, they serve the 26 or 52-week probationary period, and they acquire permanent civil service status. Also, any classified employee, either in the non-competitive or labor classes, if they're a veteran or a volunteer firefighter, may also have Section 75 rights. And we know that non-competitive class employees acquire them after 5 years of continuous service. As we mentioned, non-instructional employees with Section 75 rights have the right to representation during interrogation, and their statements are inadmissible if you don't give them representation. There's an interesting kind of gray area here. I've had the situation arise where something happens. Let's say it's a bus driver who's been there for 10 years, so they have Section 75 rights. And they drop a kid off at the wrong bus stop. So they come back to the bus garage, and the transportation supervisor says to them, "What happened?" And they tell him. I'm going to argue that that's not an interrogation, that's simply the bus driver or the transportation director trying to find out what happened so that they could fix the problem or address the issue, and that it was not an interrogation. And anything that the individual said kind of spontaneously during that that type of questioning is admissible. But there's an argument that, hey, before you start asking them things, they're entitled to representation. I think that as a practical matter, you go ahead and make the inquiries, because obviously there's some exigency to knowing where the child is and how to fix the situation as well as deal with the parents. Charges. The notice of the proposed disciplinary action and the charges are served upon the individual employee. It must be for either incompetence or misconduct. They have 8 days in which to serve a response. Here's an interesting circumstance, or difference between 3020A and 75. 75, the Board of Education only votes to appoint the hearing officer. They do not vote on the charges. So the superintendent can go ahead and serve the charges, and the appointment of the hearing officer is what is in the purview of the Board of Education. Another huge difference here is that the Board of Education gets to appoint a hearing officer of their choosing. In 3020A, the hearing officer has to be mutually agreed upon by both parties from a list of hearing officers provided by the American Arbitration Association. That is a big difference, because unilaterally choosing the hearing officer, generally you pick a hearing officer that you know to be more sympathetic to the district's perspective. And that hearing officer isn't dependent upon the union for their income. Hearing officers in Section 3020A hearings, as I mentioned, have to be mutually agreed upon. So the union has to believe that that individual is going to be giving the union member an advantage or more than a fair shake generally. The district hopes that that person is one of the more reasonable hearing officers. I can tell you, based on experience, if you get a bad decision from a hearing officer, from a management perspective, you're not going to pick that person again. For instance, our law firm picks, a few dozen hearing officers for 3020As over the course of a year. There are certain people that, based upon our experience, we don't choose. So those people are not going to work as a hearing officer for any of the districts we represent. NYSET has a similar list of people that they don't believe are favorable to the employee, so they're not going to choose them. There's really a handful of hearing officers that we can all agree upon. And that gets into an issue of how long it takes to schedule these things, because of the maybe 6 to 10 hearing officers that we find mutually agreeable. They are the busiest people. Right now, State Ed isn't paying them on time. State Ed is responsible for paying the hearing officers in Section 3020A proceedings. And they charge a per diem, travel expenses, that type of thing. And it's about 18 months out now that they're getting paid. As it turns out, those 5 to 10, 6 to 10 hearing officers are also arbitrators that the union and districts tend to agree upon the most. That work is more advantageous for the hearing officer to take because it pays immediately. As a business official, think about it. If you get a bill from an arbitrator for a labor arbitration, you pay it. So that person gets paid, within 30 to 60 days. That's a big difference between waiting 180 days for your money. And those hearing officers / arbitrators that are in high demand will give arbitrations preference over hearings, 3020A hearings. So that's one of the reasons that year and a half average to 2 years exists, because the hearing officers don't want to wait a year and a half to get paid. So they fit in the hearing dates for 3020As between arbitrations when they're available. Getting back to Section 75, the hearing officer that you pick is going to be more readily available and is paid by both parties, it's split. So generally speaking, they're going to be more inclined to take that type of an appointment. During the pendency of Section 75 charges, employees may be suspended without pay for up to 30 days. And that'll eventually get folded into the penalty. So if the individual, for instance, gets suspended for 60 days, they will have already served 30 of those days. Occasionally it takes longer than 30 days to hold the hearing, and you have to put them back on the payroll after the 30-day period. And no, you will not get that money back if the suspension is longer. So if it's a 40-day period of time that it takes to get a decision from the hearing officer, hold the hearing, get a decision, they'll be back on the payroll for 10 days. If it's a 60-day suspension, they would start that new 30 days from the date of the decision or the date of the board action, taking into consideration and approving the decision. Rules of evidence don't apply. They've generally followed to some extent, but you can get things like hearsay documents in. It's not quite as formal as the 3020A. And again, we mentioned that the statute of limitations is 18 months, except for crimes. If it's a criminal act that they're being charged with, or an act that would be a crime under one of the statutes of the penal law, then you can still charge them with that even though it's older than 18 months. Another huge difference between Section 75 hearings and 3020As is that the hearing officer's decision is only advisory. So if the hearing officer comes back and says, well, I think it's a 3-month suspension or a 2-month suspension, and the district disagrees with that, the board believes that it should be termination, they can dismiss the hearing officer's recommendation and impose their own penalty of, say, termination. Now that can be appealed pursuant to Article 78 of the CPLR, which is the Civil Practice Law and Rules of the State of New York, which means that it goes to your local county Supreme Court, and they look at it and they say, was there substantial evidence to support both the finding of guilt as well as the penalty? And was the penalty grossly disproportionate to the offense? So let's say the hearing officer recommends a 3-month termination, and the board says, nope, damn it, we want termination. It's termination. So they impose a penalty of termination. The employee may appeal that to the local Supreme Court, and the Supreme Court will make a decision as to whether or not that penalty, well, first they'll decide whether or not the employee did what it is he was alleged to do. Is it more likely than not substantial evidence that he did what it is, whatever act of misconduct or incompetence it was? And then they will make a determination as to whether or not the penalty was grossly disproportionate to the alleged conduct. And they do overturn school boards. Probably less often than not, they will uphold the determination of the school board. But usually if it goes to an Article 78 proceeding, there's a feeling on the part of the union that the punishment was grossly disproportionate. And oftentimes the court will agree and either remand it for a new penalty or indicate to the board what they believe is the appropriate penalty. All right, this is change. There are significant changes going on right now in 3020A with regard to pedagogical incompetence that have to do with the new APPR, and I'm only going to touch upon those briefly because that could be an hour-and-a-half conversation in and of itself. But for both Section 75 and for 3020A, you have to remember the view of the hearing officers is that the purpose of discipline isn't punishment, it's remediation. The idea is to get them good or get them gone, but only after you've made sufficient efforts to get them good. So this ties into the whole idea of progressive discipline as well. What the hearing officer is going to say is, all right, did the employee know what the expectations were? Did the employee fail to meet the expectations? Was the employee warned about the consequences of failing to meet the expectations? Was the employee given the resources necessary to meet the expectations? And if the employee still fails to meet the expectations, what can this disciplinary process do to remediate that failure? What can it do to make the employee understand what the expectations are, how to meet them, and get them to do the job right? That's the purpose of discipline from a hearing officer's perspective. It's not to punish them for their behavior, and it's not to terminate them unless it's demonstrated that they cannot get better and they cannot perform their job. So that's the perspective when you go to a hearing, whether it's 3020A or Section 75, that you have to realize the hearing officer has, and you have to be ready to prove that you've done what you could to get the person to perform appropriately. Now, how do you do that? Performance appraisals. And again, this is both for teachers as well as non-instructional employees. With teachers, the formal aspect of this is the APPR, and it has to do with traditional classroom observation. Under the new APPR, that's going to be probably, in most cases, 60% or more of the person's evaluation. The other 40% is going to be based upon student assessment data. There's an evaluation form, and there's generally some sort of an exchange conference. Those are important because those are all those, they meet all those elements of what the expectations are. So the meeting or the exchange conference, there may be a pre-observation exchange conference at which time the parties share with each other what the expectations for performance are, whether it's in the classroom or in the school building in a non-instructional capacity. Then there's an observation of the work being performed, again, either in the classroom or for non-instructional work in the work environment. And then there's some sort of an evaluation form, which is filled out by the evaluator and summarizes what their observation of the employee was. And that is followed, again, usually by some sort of an exchange conference, which says you met or you didn't meet the expectations. And it also provides an opportunity for feedback from both parties with regard to the expectations, the observation, all those things. Those are important elements to be able to demonstrate to a hearing officer were appropriately conducted so that all those elements of progressive discipline were met. Informally, oftentimes a supervisor has notes regarding conversations that they had with the employee about particular aspects of their job performance, which may have been critical or may have included praise. Counseling memos are of huge importance in terms of documenting the fact that the person's been put on notice that there are deficiencies in their job performance. And that's generally outside of the traditional evaluation process. Again, most people think of this as creating a paper trail or papering the file. And I can't tell you how important that is. And it's important that the evaluation matches up with the counseling memos. Oftentimes, I'll get a call from a supervisor, a superintendent, a principal, a non-instructional supervisor, whomever, say, look, I've got this problem with this employee. He's doing a terrible job. He's been doing a terrible job for years. What can we do to get rid of him? And the first thing I ask for, well, can I see his evaluations? And you look back for 2 or 3 years, and the evaluations are not particularly critical. They're not bad evaluations. They're generally satisfactory. And maybe there's one counseling memo in there about a critical incident, but really nothing that would amount to much. And I say, look, you need to do a critical evaluation. You need to tell this person where they're deficient and tell them how to get better. And generally speaking, that's got to be over an 18 month to 2 year period where you can demonstrate that you've given fair warning to the person that their performance is not meeting expectations, that you've described to them what the expectations are, and you've attempted to remediate it and you provided them resources to get better. All right, this applies to both instructional and non-instructional employees. And you have to check your contracts. The new APPR is changing everything. So the new APPR is going to be, pretty much everything's going to be a mandatory subject of negotiation, is a mandatory subject of negotiation. And it's currently being worked on in most of your districts. Very few districts have a completed APPR. But they call for many of these things, and some of them will be contained in non-instructional contracts as well. So that probationary employees, there'll be an expectation that during the probationary period they'll be evaluated at least once, maybe twice, that they'll be given feedback, and that after that, the permanent employees will have some sort of an evaluation process as well. And again, you really need to look at what your contract has to say about what the evaluation process is. There's an interesting difference that exists now with the new APPR regulations between instructional and non-instructional employees. Most of the elements of the APPR are now mandatory subjects of negotiation. And to some extent, districts throughout the state are struggling with how to negotiate what an APPR should look like under the new commissioner's regulations and the new law. There used to exist for APPRs a dichotomy between the criteria and the procedures for evaluation. So the criteria, what good teaching was, what it looked like, was a mandatory subject of negotiation. The process by which you observed and evaluated whether or not an employee was meeting the criteria was a mandatory subject of negotiation. Now that line is very gray, very fuzzy, and honestly, for the most part, the new APPR law and regulations have converted just about everything to a mandatory subject of negotiations. But the dichotomy is still important for non-instructional employees, because what the expectations are for, say, a custodian, what good cleaning is, what good custodial work is still a management prerogative. So you can define what the criteria are in the evaluation process. The process by which you evaluate them, how you observe them, the forms you use to fill out, those types of things are mandatory subjects of negotiation and are oftentimes contained in the collective bargaining agreement. Also, non-instructional employees are probably the least evaluated employees. Many districts don't do it annually. They don't use the right form. A whole host of problems arise. And when it comes time to impose discipline, that can be problematic because you don't have that paper trail. All right. What does an effective formal evaluation look like when you're talking to the employee about it? You go through the report in detail. You don't just and say, here's your annual evaluation. You don't want it to be a threatening environment, even if the evaluation is critical, because remember, if this does come to discipline, you're going to be put on the stand, or the supervisor is going to be put on the stand, and the tone of that conference could be important in the hearing officer's decision as to whether or not you tried to get the person better or you were just playing out to get them. Have the employee discuss how they think they're doing verbally. That gives you a sense of their self-awareness, whether or not they realize they have strengths and weaknesses. Some employees, they don't have the introspective capability of seeing their own weaknesses, and they get very defensive when they're pointed out to them. But one quality of a good employee is that they have the ability to be self-reflective and can identify where they can get better. Emphasize the areas that you agree upon. Generally, those are going to be areas where the employee does a reasonably good job, but at least that creates the impression that you're being reasonable with them in the sense that you are recognizing what it is their strengths are. But be truthful about discussing the deficiencies. This is generally something that educators have more of a hard time with than non-instructional supervisors. Positive reinforcement can be a great benefit to kids, where they respond very positively to praise. And sometimes instructional leaders allow that philosophy to branch into their interactions with adults in the building, and they tend to sugarcoat things a little bit because they don't want to be critical, or they don't want to be seen as being antagonistic. You can give criticism without being antagonistic. You can give criticism in a constructive way, and your best employees will see it as that. But you need to be forthright and tell them what the problems are, because, again, when it comes time for a hearing, were they on notice? Did they know where their deficiencies were? Recognize the legal role of the evaluation. If it looks like, if you're doing an evaluation on somebody that you think is destined for a hearing someday, regardless of your best efforts to remediate their behavior, realize that you're going to be cross-examined on that evaluation. You're going to have to say, yes, the person is deficient in these areas, and you're not going to want it so watered down that it isn't clear to either the hearing officer or the employee that you told them outright, this is bad. Also, be able to back up your observations with facts. Use uncomplicated language, be very direct and specific. Give examples of what you're doing and give suggestions to improve, whether or not that's staff development or just simple direction with regard to different resources that are available to the employee in the school to make their work more efficient and effective. Again, 3020A says that the hearing officer shall consider the extent to which the employing board made efforts towards correcting the behavior of the employee which resulted in charges being brought under this section through means including but not limited to remediation, peer intervention, or an employee assistance plan. Teacher improvement plans are going to be are required under the new APPR, and their requirements are considerably more stringent than they have been in the past. I encourage the use of improvement plans for non-instructional employees as well, and they should contain all of these things. They need not be extravagant, but the principle behind this is, at the hearing, I can break out the improvement plan and demonstrate all those elements of fair warning that the person had in the effort to remediate. So I would say that this applies to both 3020A as well as Section 75, and you can use it for both instructional and non-instructional employees. You want a clear statement of the problem and concrete goals intended to eliminate the problem or the desired outcomes. You want to offer the individual strategies for accomplishing the goals. And you have to tell them, how will we know when you've completed the goals or you completed the plan? What is the assessment we're going to use to determine you either successfully completed the plan or you failed at completing the plan? And you want a timeline for those goals to be met. I've seen any number of improvement plans that are simply saying, this is what you're doing wrong, we expect you to do this, and they leave it at that. And it's given to the person at the beginning of the school year, and it isn't mentioned again until the next evaluation or the end of the school year. That's not good enough. That's not going to pass. You need to have structured timelines in order to give the person feedback on how they're progressing with the plan, and you need to have a specific end date in the plan that includes benchmarks for whether or not they've accomplished the goals. Yeah, only one problem for problem statement. They should be specific, and they should identify all the teacher's problems. The statement of the goals, you may want one or more outcomes for a particular goal, but not more than one problem per goal. And each goal should be related to the problem statement. A goal should be specific enough so that it can be determined that the goal has been met. That's the key, really having specificity in there. And again, this is with get them good or get them go on. You got to target strategies for the person to be successful, and they need to be logical in time frame as well as progression. You want them to include remedial efforts that are going to help them carry out the strategies and reach their goals. And the statement of evidence of completion. How are you going to know that the person completed the improvement plan? And that's going to involve some sort of empirical evidence, whether in the case of non-instructional employees, it's, the filing of paperwork timely, or instructional employees, improved achievement by the students, or perhaps more of the curriculum being covered during the course of a quarter or a semester. And the completion dates, they've got to know when the improvement plan is going to end. Yeah, I can't tell you how many, and this is true for evaluations as well. It gets pointed out in hearings if there are grammatical errors or spelling errors. How can you have an expectation, for instance, that an English teacher is going to have strong content when the evaluator can't put a sentence together in the evaluation or in the improvement plan? It just becomes a lot harder to defend if the evaluator can't demonstrate that they're not holding the teacher or the non-instructional employee to a higher level than they themselves have obtained. The format for the action plan should enable the teacher and the principal to easily follow the sequence. So it should be well written, and the administrator must successfully implement it. So if you do put timelines in there, calendar them. Make sure that you're meeting the obligations, your obligations of the improvement plan. You're getting back to the employee. You're meeting with the employee. You're providing whatever resources you promised to provide in the improvement plan. That is a great burden on supervisors and administrators, but it's necessary in order to defend the improvement plan at a hearing. Meet with the employee and review it. Discuss each element. Explain the basis of each concern. It's no different than an evaluation, really, except you're going to describe to them how you're going to measure the outcome of the plan, create a timeline, and give them resources. And again, it's all about follow-up. You really need to follow the plan to make sure that you're meeting the timelines and that you're in pretty consistent contact with the teacher or the non-instructional employee. The assessments, regularly scheduled intervals at normal break times, end of the semester, holiday breaks are generally good times for that, or whenever the administrator deems appropriate. And again, the plan may be assessed on completion dates contained within the plan. Progressive discipline. A hearing officer, a panel, or an arbitrator will generally permit an employee or an employer to discharge an employee only after he or she has been given a warning and a chance to rectify his performance. That's generally true. There are some things that are so bad that will get them fired in the first instance. And generally that has to do with health and safety issues of students or issues regarding criminal activity. So generally speaking, if it's a performance issue, a competence issue, you're not going to get rid of somebody on the first try. If it's a misconduct issue, your chances are much better depending upon the nature of the misconduct. Sex, drugs, and violence are the best ones. If an employee is engaged sexually with the student, obviously that's an issue of misconduct and will most likely result, if you can prove it, in termination in the first instance. If there are drugs involved, it's not quite as clear, but generally speaking, depending upon the nature of the transgression and whether or not the employee has sought appropriate treatment, drug and or alcohol abuse treatment during the pendency of the disciplinary proceeding, you may be able to get rid of an employee based upon one instance, especially if they're in a safety specific area such as bus drivers or bus mechanics, things of that nature. And violence generally, if there's a belief that students are in danger, you might be able to get rid of them in the first instance as well. Progressive discipline means that only after a specified number of offenses, regardless of whether or not the offenses are identical or not, the company may have the right to discharge the given employee, particularly where the employee, by his total behavior, shows himself to be irresponsible. So what's a normal line of progressive discipline? Remember, counseling memos only go to notice. They're not discipline. So that doesn't really constitute progressive discipline. They're good, however, in the sense that they indicate that the employer has told the employee that they're doing something wrong and instructed them not to do it again. The next level, depending upon whether or not it's an instructional employee or a non-instructional employee, may be a written letter of reprimand. That differs from a counseling memo, really pretty much in name only. The consequence is a piece of paper in the file, but a letter of reprimand is formal discipline and counts towards progressive discipline. A counseling memo does not. The next level might be a fine or a suspension, and after that, either a greater fine, greater suspension, or termination. And the extent to which you have to go down that whole chain really depends upon the nature of the activity or the charges and is very fact-specific. Even if the collective bargaining agreement does not directly affect or apply to the discipline of employees, it could have an indirect effect where, for example, negative performance evaluations or counseling memos were not properly placed in the employee's personnel file. So again, you have to constantly go back to the collective bargaining agreement. And remember, it can give them greater protections than either Section 75 or 3020A. Generally speaking, there occasionally are alternative processes in the collective bargaining agreement to 3020A. They are rarely, if ever, utilized. So for instructional employees, really, it's pretty much plain vanilla 3020A. That's what you get. That's not the case with Section 75. Well, more often than not, non-instructional contracts include provisions that give greater rights or extend the rights of Section 75 to other than competitive class employees or non-competitive class employees with 5 years or more experience. So they can extend them, for instance, 75 rights to all employees after their probationary term. Or they can enhance Section 75 by saying that the hearing officer has to be mutually agreed upon. Or they can take it out of Section 75 entirely and put the disciplinary process into the grievance procedure so that you have a mutually agreed upon arbitrator whose recommendation is binding. So it's not a recommendation, it's really a binding finding that the school board cannot decide to accept or reject. And that's none of those are uncommon. It's very uncommon, I believe, in my experience, to see a collective bargaining agreement for a non-instructional unit that doesn't either enhance or give benefits in addition to Section 75 of the Civil Service Law. So it's important always to go back to the collective bargaining agreement. You also have to look at what the process is in your collective bargaining agreement for placing materials into the personnel folder. regardless of whether or not they're critical materials. Generally speaking, most collective bargaining agreements have language that say that the employee is entitled to know when critical material is placed in the collective bargaining agreement, and they have, into the personnel folder, and they have the right to inspect the personnel folder. Generally speaking, employees have the right to reply to counseling memos and evaluations. There may be limitations on transfers, so you may not be able to transfer someone as a remedial measure. Sometimes you can do that, and especially in circumstances where an employee says, hey, look, this isn't about me. My supervisor can't stand my guts because our cousins are getting divorced, or for whatever reason. And it's a personality conflict. So you move a custodian from one building to the other. And maybe that takes care of the problem, maybe it doesn't. Your ability to move that custodian may be impacted based upon what's in your collective bargaining agreement. And again, the number of evaluations and notice requirements contained in the evaluation process are important as well. All right, just cause. What is just cause? And it can apply both to Section 75 as well, and it definitely applies to 3020A, but a lot of collective bargaining agreements have a just cause clause in there somewhere with regard to disciplining. And it means that there's basically a 7-pronged test to see whether or not there's just cause to discipline a person. And that involves 7 different questions. Did the employer give to the employee forewarning or foreknowledge of the possible or probable disciplinary consequences of the employee's conduct? Was the employer's rule or order reasonably related to the orderly, efficient, or safe operation of its business? And did the performance of the employer might properly expect from the employee? So was it a reasonable directive? Did the employer, before administering discipline to an employee, make an effort to discover whether the employee did in fact violate? So your investigation comes into question here, and that's something that you have to prove that there was a preliminary investigation and that it was conducted fairly and objectively. Is the substantial evidence or the proof that the employee is guilty is charged? Substantial evidence means that it wasn't more likely than not that the employee did what he is charged with. So you can think of that as kind of 51% of the evidence demonstrates that the employee is guilty of what they're charged with. Has the employer applied its rules, orders, and penalties even-handedly and without discrimination to all employees? All right, so you're going to ding an employee for spending an inordinate amount of time surfing the internet. You know, it's early December, and lo and behold, they're on the LL Bean website for 3 hours a day, and you want to discipline them for that. Well, the question is, among many others, but one of the questions in this test is, have you been looking at the internet use of other employees? Have you told the employee they can't do that? Are other employees doing it and not being disciplined? So you have to make sure that you're not singling out the person. Was the degree of discipline administered by the employer in a particular case reasonably related to the seriousness of the employee's proven offense and the record of the employee and his service with the employer? This is a big one, because what you have to realize is that a long-term employee, somebody that's been there for 15 or more years, is not going to get terminated easily. This is something that hearing officers take into consideration when deciding what the appropriate measure of discipline is. And a lot more deference is going to be given to a long-term employee. And generally speaking, I'm going to say, based upon the decisions I've seen, that's somebody with more than 12 years experience. It's not a bright line, but certainly somebody with 25 years experience, 30 years experience is going to be given a great deal of deference. I had a decision a couple of years ago where an employee with 9 years of experience The hearing officer specifically said it's not a long-term employee, we're not giving a lot of deference to their service to the district, and that resulted in termination. So it does matter how long the person's been with you. All right, counseling memoranda, Holt letters. They're not discipline. A Holt letter, Holt refers to a New York Court of Appeals case, that's the highest court in New York State, that said that you could put a critical letter, counseling memo, into a teacher's personnel file. And they differentiated a counseling memo from discipline. Now, this differentiation exists for both instructional and non-instructional employees, so it's important in both contexts. It should be issued by the supervisor. So whoever the immediate supervisor is should be the person putting the counseling memo in there, not the superintendent if the superintendent isn't the immediate supervisor, and not the Board of Education. Again, a court or hearing officer could see that as discipline as opposed to counseling. It should be based upon personal knowledge and an investigation by the supervisor. It should contain directions for future conduct and contain warnings of the consequences for future violations. The Holt letter is not an adjudication. You're not finding the person guilty of something. It can be used in evidence in a disciplinary hearing to show that the employee has been warned or put on notice about similar misconduct. They should be specific, when, and where of the incident. That's important. Exactly what happened, who was involved, what was wrong about what occurred. What must be done immediately pertaining to the specific incident, how the employee should handle such incidents in the future, any resources you can give them, and the possible consequences if it happens again. And there's a form for this. This is, in essence, the type of counseling form that we give to our clients to use. It's really a template. It's in 2 slides. And the employer and the employee both sign it. And there's an opportunity generally for the employee to respond to it, and the response will be copied to the personnel file as well. That is pretty much my presentation on discipline of instructional and non-instructional employees. I'd be happy to entertain any questions if anybody has any.
Okay. If anyone has a question for Eric, please hit 7# on your phone to talk to him, or feel free to go ahead and type in the chat window for us, please.
One thing I could talk about a little bit while we're waiting for that, if there are any questions, is the changes in 3020A. As many of you may know, the new APPR law and regs are calling for an expedited 3020A proceeding in cases where a teacher has received 2 sequential ineffective evaluations. And that process, while I am not comfortable for the reasons I discussed before in saying that it's going to be any quicker than it has been in the past, especially with SED not paying the hearing officers and there being so few hearing officers that both sides can mutually agree upon. I am encouraged that the language of the statute says that those 2 ineffective evaluations shall be strong evidence of incompetence. That's the exact language of the statute. And I think what that does is create a presumption at the hearing that the teacher is incompetent. And from my perspective, it should shift the burden of proof onto the teacher to demonstrate that there's something wrong with the evaluation, that they are in fact competent. And that's a big difference. I think that there is the potential in the future, and it's going to be many years, perhaps as many as 5 or more, before we really get a sense of how it's going to operate. But there is the potential that it can help get rid of truly incompetent teachers in a much more effective and expedited manner.
Okay, Eric, we have no questions in chat, and no one has raised their hand to ask any other questions. So thank you very much for presenting for us today.
All right. Thank you, everyone, and have a good afternoon.
And thank you all for coming. Have a great day.
This conference has not started or has been paused by the moderator. You will be placed on music hold until the conference begins.